Good evening, everyone. Today has been kind of a whirlwind day here in Florida. I'm talking softly for two reasons. One, we just put my daughter down for like a mid-evening nap. I don't know. We went to one of those um, almost like a ball pit, but it's like a modern one, and we think she might have gotten sick. So she's taking a nap. The other reason is it's kind of a somber day here in Florida. Um, as we all saw, shooting at FSU. I'm not going to like speculate as to what the motive is or anything like that. I wait for facts. I live in facts and evidence, and I've just heard theories and about what's going on. Um, I ultimately think yes. I think the death penalty will be sought. I think there's going to be wrangling between the both the federal government and the state of Florida. As we know, the supremacy clause, federal laws trumps state law. So, but I think the only thing I'll say is that my thoughts go out to the victims' families and all those affected. That's not something that's easily forgotten, and we just hope that one day they'll maybe see some peace. But I think that's all I'm going to say to not go on a political or anything like that. So we are about to have opening statements next week. And we finally get to the end of the road. Men and 9 women will decide what defendant Karen Reed is guilty of. I've previously said on many occasions it was um, it was a horrifically terrible mistake for her to do the documentary. But I can tell you that it definitely felt like Alan Jackson and David Yannetti, Elizabeth Little thought this was going to be a documentary showing them their greatest success. That they expected this to be an acquittal outright. And that's unfortunately a mistake at one point all trial attorneys do. You think you got something won, but you just don't know. Here's the most important thing in a jury trial. You just never know. You don't know. You think with the facts and evidence say one thing. I'll give you a perfect example. The Curtis Reeves case, movie popcorn murder trial. I think that's what Court TV said. And I did not see anything. I didn't hear anything. I watched the case. I was on it with Jesse Weber pretty much weekly. And I didn't see anything to support an acquittal in that case. But that's what happened. And then I remember he's like trying to act like a frail old man. And then the second the acquittal came, he rushed out of there with speed that I hadn't seen throughout the whole trial. There are situations where you're going to win cases you think you're going to lose, and you're going to lose cases you think you're going to win. That's the practice of trial. That's trial law. That's being a trial attorney, very simply put. So when I watched that documentary, it came off like, look at my greatest success. When in reality, no, you just had your client testify, and now her statements are going to be introduced, and you might actually force your own client onto the stand to explain those. Because some of them are, it's like, I never saw John go into the house. That might be the biggest piece of evidence against that I think that have come back into this case in chief during opening statements, because then it kind of corroborates that nobody, including the defendant herself, saw John O'Keefe enter the residence. And if nobody in the house saw it and the defendant, it's pretty tough to assume that actually happened. So when you think about the facts and circumstances when doing the documentary, it's like you're expecting to win, because if you lose, or if this comes back worse, which is a hung jury where you have to do it again, the case just got stronger because the defendant didn't take the stand. The defendant doesn't have to take the stand. But by doing so, by making those, somebody's going to have to take the stand to explain that. And you don't want the defendant ever taking the stand except in a self-defense case. I was on Court TV with Julie Grant yesterday, and they're showing a clip, and it might have gone over everybody at Court TV's head, like why it was such a bad response by the defendant. Alan Jackson figured it out immediately. She's talking and they're like, "Do you know who did this?" And she kind of looks at them with disgust and she goes, "We know who did this. We all know who did this." And Alan Jackson realized that's a quasi admission by not saying it. Well, no, it was not me. We know who it was. That's a statement that could come in. It's like you were given an opportunity to deny it, and you didn't really. It's like, oh, she shouldn't have to deny. It's like, well, that's not how it works. That's not how admissions work, and in the admission of them into evidence. So Alan Jackson realized that immediately, and he's the one making the denial. But it doesn't change the fact that that's what the defendant said. And then you see another interview with Ted Daniel, and um, he's like, "Do you know who did this?" Like, we don't know who did this. And it's like, okay, so now the story's changing. You said you didn't know this, who did this to Ted Daniel, and now you're saying to this individual, to this reporter on the courthouse steps, we all know who did this. It's like, you just said you didn't know. Now you know? Or then the jury's saying, it's like, this is not consistent. This is starting to not make any sense at all. And then you think about it, it's like, oh, it's because probably the person who knows who did it, it's the person sitting in the defendant's chair. So, like I said, again, it was just a colossal mistake, and it was a victory tour. Look at how great I am, and don't ever put the cart before the horse, and especially not in a high-profile murder case where a jury's deciding, and literally anything can happen. So yeah, that's kind of that's how I see Hank Brennan kind of bringing those in, because you kind of destroyed the defense's case before they stand up, because you know what it's going to be. It's going to be Michael Proctor, Michael Proctor. They didn't write it down. Inverted Sally Port videos. And it's like, oh, well, it was a dog bite. And it's like, come on. Like we're going there. And it's like, but Hank Brennan is kind of going, like I said, he's going to be trying to prove a direct evidence case using a circumstantial method, which I think is the right call here. What I can say with the ARCA witnesses, and it's just going to, they're not going to have much credibility this time around, because it was pretty clear in the first trial they were hung out to be independent witnesses, and when in reality you see the messages between ARCA and the defense team, and like, hey, should I say this? And it's like, not what you're doing. You can prep them, and it's like, oh, what's the best way to say it? But asking them what to say, that's not going to show independence. And then when you try to bring up the feds investigating, it's like, well, they were hired by the feds. And it's like, well, the feds closed their investigation. And it actually appears, what I saw in the discovery, that the Canton audit may be introduced by Hank Brennan, maybe in the case in chief, but more likely in the rebuttal when they try to talk about corruption and stuff like that. It's like, this was an independent thing. They spent like 180 grand on this audit, and they found no corruption. They saw mistakes were made, but they didn't find this conspiracy. And it's not there. It's never been there. So I can tell you, when you like looking in court, I don't see the same confidence that I saw in the first trial. They came in and they were like, we know this, boom. And this time around, it feels like they're going through the motions. Sure, yeah, it's exhausting to do another trial. And that's why it was so huge for the district attorney's office to bring in a new lead prosecutor, because you could see Elizabeth Little, David Giannetti, and Alan Jackson, they're fatigued. They're like, we just did this last summer, and now we have to do this again. And if they don't do the retrial, they look like they abandoned their client. And that's not good for their brand, because there's going to be other cases for them after this. And if their clients can't trust them to be there and get them through this, they're not going to, on the biggest stage in the country, people aren't going to be banging down their door. No matter what. And it's like a situation, people believe the conspiracy, and the people who just like attack other people online, calling them McAlberts. it doesn't matter. There could be a jury verdict and for guilty, that they're still not going to accept anything they find. Um, why is David Yannetti stepping away and George stepping in? I don't know if Yannetti's really stepping away. I didn't think he was that great in the first trial. Um, honestly, he had some good moments, but I probably give him a C plus. I thought Alan Jackson was a lot better. As much as I don't agree with the tactics and the conspiracy angle and trying to villainize innocent people, I thought he did his job in sometimes, but I didn't think Yannetti was effective at all. So it's possible Victoria George is brought in maybe to give like a different perspective as been an alternate juror and knowing what the evidence is and what to, because I don't think she has criminal experience. I think she was an employment attorney. I'm trying to remember. Um, so it is pretty difficult. Like when you have that many people, and Lacey was coming into this case because, and it's just everybody's just looking for the publicity associated with it. But that only plays if you're going to secure an acquittal. Like I remember when I was like, it was a case where it was like a staged suicide. I want to say it. I forget who was it was out of Ohio, and I think the defense attorney might have handled it pro bono, and that was a case that the individual was acquitted because I think that attorney had just done the nurse who was like giving people fentanyl, calling it comfort care, and like prosecuted it with Jose Baez, who was acquitted. So that's kind of when you do like one of those pro bono cases, you need to win because the publicity is good, but it's not going, people are going to wait and be like, oh, this person got, that's how it is. When you practice criminal law and you own your own firm like I do, your brand is results. Like you could provide great representation, ask all the right questions, but people want to know that you are going to win their case. And they feel comfortable giving you their money to be able to represent them in court because there are a lot of bad attorneys out there and a lot of bad trial attorneys out there who will take your money and then they won't do the job that is needed to. So it's, I don't think with all the extra attorneys they're adding, and I think they had like 9 Harvard law clerks working on their case. I just don't see it this time around. I feel like there's just something different. Every time the defense walks into the room, it wasn't the swagger that they did. Yes, it's like, oh, they're under the gag order. Yeah, I can see that. But just in the courtroom, um, yeah, it's just night and day. Hi, Matt. What's it like to be a defense attorney and flip to prosecution? Wondering what that is like. So when I was a prosecutor, prosecution tends to be much more political. When you're enforcing the law, and when you're a prosecutor, it's kind of like you need to understand the power that you have to be able to do this job. And the great prosecutors, they understand that and like know that you're going to resolve cases you don't really want to, so you know the greater good. I'll give you an example. I had a kid who was 18 years old. He didn't grow up with a father, and his brother was in and out of prison. And he got like a fleeing to elude. And then like 2 weeks later, he got another one. We did the first trial, and I knew I could have connected the cases together. But the prosecutor was trying with I didn't like, we had kind of a rough go of it to start, and I wanted to kind of repair that. So I didn't really want to show her up. So we lost the first case, and then we had the second case. We had the guy dead to right. And I'm like thinking to myself, I'm like, if I go to trial and win, this kid's adjudicated for life as a convicted felon. It's mandatory on a fleeing to elude. And I had him. And he won the first case. So I called my boss and I'm like, I don't want to adjudicate this kid. This is not the greater good. This is not what we are searching. This is not what I am here to do. And he's like, well, you lost that case and you lost that case and he made a fool out of you. Don't you want him? Like, no, he didn't. He was a scared kid. He got pulled over and he ran. He's 18 years old. He has no criminal history. And eventually my boss allowed me to amend the charges to a couple of misdemeanors, reckless driving, resisting arrest without violence, and like put him on probation. And I haven't heard any issues, and I've checked since. So when you think like that as a prosecutor, you know that you're probably not longed for being a prosecutor, because I can tell you my old colleagues who are still at the state, they are being asked to do things that that the higher ups have made the decision, you got to go forward on that, or the laws have changed and they have to enforce them as such even though they don't agree with them. So I'm glad now as a defense attorney that I got to help victims and be able to prosecute crimes, hold people accountable. But as a defense attorney, you can also do that same thing. You can help defendants. I handle a lot of nonviolent offenses, people who are doing like drug addicts, who, because there's a difference between dealers and sellers. Um, and if you take away enough addicts, the sellers aren't going to have anybody to sell to. You got to get them treatment. So when I take over a case and they're usually in jail for a bit, because it allows them to clean out. And my mother's on the board at Dana-Farber, and they did a study, very expensive study. And what they found is you cannot get anybody to seek treatment unless they want to. You can't force it to them. They have to choose to do it on their own. It will fail every single time. So when those defendants are in jail and they're thinking about it, they're like, yeah, I don't want to be in this cell for the next 3 to 5 years. I want to get treatment. I want to be better for my family. Those people I can help. So when flipping over to the defense side, I get to be able to. So I didn't have to, when I became open my own law firm, I didn't have to listen. I didn't have to take orders from the higher ups with things I didn't agree with, who are doing things politically. I don't really want to go into some of those stories, but yeah, there was definitely politics involved. And hey, we need you to ask for this sentence on this case. Why? Because this defense attorney, and I'm just redacting the reason why. And I wasn't okay with that. And so now I get to make the decisions. I get to treat people how they deserve to be treated. I have an assistant, I've had interns, and it's about making everybody feel like a team. And you just don't get that. You kind of, at the state attorney's office, a lot of them, what they want to do is especially when they get to the felony division, they want to just they want to do their cases and go home. They don't really want to try cases. They only want to try cases that they can absolutely know they can win. It's that simple. Because when I was at the state, we'd have Friday meetings where it would almost like turn into like a autopsy of the cases. When in reality, it's just a shaming. If you won, great. But if you didn't, everybody just took turns being like, why didn't you do this? And it's just Monday morning quarterbacking. And none of the prosecutors want to deal with that. So a lot of people, what they do, defense attorneys, is they just sit and wait for the prosecutor to fold and give them the deal that they should have given 6 months ago. Because once they're on the eve of trial and they can't continue the case, that's when you get the best deal. So do you think Karen Reed has done all the interviews documented with her attorney's consent? Yeah, she's not going to, at this point, like be like, hey, I'm going to do this documentary. Should I do this? And my thinking would have been is like, yeah, I don't know how much good this is going to do. Are you getting paid for it? Or is this just about getting your story out there and doing the vanity exercise? Because if it is, that's not good. Because if you don't win, if this case ends in a retrial, you can be damn sure this stuff is going to be played. And guess what? It's going to be. Is it possible this is a challenge for Brennan? He is a nuclear cross attorney. Thank you for taking the time to answer. I think Hank Brennan, every trial, especially in a high profile homicide like this, is a challenge, because there are just so many different elements to it. It's not just, all right, here are the facts and evidence in this courtroom. And that's the way it should be. It's like, we're only doing that. There's everything that's going on online. It's the people involved, the community. It's like the people wearing pink shirts and people wearing blue shirts outside and the buffer zone. Hank Brennan was brought in because he can ignore that noise. I don't know if 88 Lally would have been able to, especially with the new added attorneys. I think it would have been a challenge for him. But Hank Brennan is one of the top attorneys. He's probably a top 3 trial attorney in the Commonwealth. And if that's who you're going to have going against Yannetti and Alan Jackson, that's probably the person you would do. So, do you think Brennan's focus on Reed's statements might indicate the vehicle data is less compelling than anticipated? So that's a great question. No, I don't think that's the case. Because remember, the standard is beyond a reasonable doubt. Every single thing you have that you can put forward to prove guilt or prove a fact you want in your case. You don't want to leave things out. That just because we're talking about the statements doesn't mean that the vehicle data, it could be, but anything and everything to go towards proving the case, you want in evidence because it's such a high standard, and there's going to be people that are going to have issues with the investigation. There are people who are going on the jury, no matter what, are going to have issues with Michael Proctor. They're going to have problems with the inverted Sally Port video, with the Stop and Shop bag and the red Solo cups. But you need to be able to put as much evidence that they're not going to be able to ignore what the evidence is saying, because the jury instructions very clearly say that you need to consider the evidence presented. Does Turtle Boy have to take the stand and plead the fifth, or when he went to sidebar, judge accepted his fifth? Yeah, when he went to sidebar, that well, Hank Brennan wants him to do it at trial because because he wanted the image, because he knows that if he's taking the fifth on the witness intimidation, it would just tell the jury, it's like boom. He's protecting himself, but he also could be protecting her, and that could go to consciousness of guilt. So I think that he's not ultimately going to have to do it. It might be at sidebar, just simply because I think Judge Canonian is thinking that if he took the stand and did that and was required to do the Fifth Amendment, it might be a situation where it could be appealable issue, and it could be indirectly affected against the defendant. Hank Brennan is extremely skilled cross-examiner. Yes, absolutely. And it's going to help huge when the ARCA witnesses take the stand and he eats them for lunch, and then does the same with the dog bite expert, because he knows exactly what, he knows exactly what is going to be relevant and what a jury is going to want to hear, and what they're going to, because people say it's a battle of the experts. That's what people say don't really know trial law, and that's more civil. It's facts win cases. That's the most important thing to know. Can you please explain why the witness intimidation has been allowed? Because it goes to consciousness of guilt. So if the defendant, so you think about it, it's like, why would the defendant be instructing Turtle Boy to, or whatever, or talking about these individuals if she actually thought that she had nothing to do with it? That's not what an innocent person does. It's kind of what a guilty person would do. So that's why it would come in. Please define reasonable doubt. So many different versions floating around. So a reasonable doubt is not a mere speculative doubt. It is not an imaginary doubt, and it's not a forced doubt. It's a reasonable doubt. It's one fact that could affect one element. That's what you need for reasonable doubt. Each one of the charges have elements. And if there is one reasonable doubt for one element, you can't prove that charge beyond a reasonable doubt. Because I'll give you an example of reasonable doubt. Most people remember the Casey Anthony case. She shouldn't have gotten off. She did it. It's in my opinion, it's pretty clear that, but the medical examiner took the stand and she said, I don't know how the child died. So that how the child died was a big, big issue, because it was either accidental or whether it was homicide. And if she can't do that, it doesn't eliminate the possibility that it was an accident. That's why she was acquitted, not because, well, and not in the fact that they didn't, as Jose Baez said, they didn't ping her, introduce the evidence of her phone pinging in the area, which would have been very difficult. Can he still be called as witness even though he invoked his Fifth Amendment? Not to prove anything against the witness intimidation case. That's what I would probably say. So he's going to be able in court and stuff like that. I think I saw that there are a situation where that he's going to be in. So anybody where there's part of the witness intimidation case, he's going to be out of court. But when they're not, any kind of the witnesses. He won't be in court, but when they're not in, he'll be able to be in. So it is. What do you think about the latest ARCA filing? Feds define scope under seal. It's the ARCA filing. It's in a position where I need to that they need to either put up or shut up. They need to show the evidence. They can't just be like, hey, what are your findings? And basically giving it the day of trial. That's not how discovery works. It needs to be given before the case and before it's ever, both sides are entitled to a fair trial, and they need to know what they're going to say ahead of time so they can properly prepare. That otherwise it leads to unfair surprise. Hey, Matt, I wasn't clear. Can you explain why witness intimidation out in the community was allowed by the police? Why wasn't it stopped? Well, the defendant was arrested. I don't know how many times for this. And because you run into the First Amendment. You don't have the right to yell fire in a crowded theater. So there's a Supreme Court case, Chaplinsky v. New Hampshire, where it kind of lays out what is allowed and what isn't. And witness intimidation is you can, when you are threatening or coercing somebody not to actually testify and try to scare them into actually exercising their right to as a witness and putting them in fear for their safety, that's not allowed. But you can, if he had the opinion, you did this. But the problem, what is ultimately going to happen with Mr. Kearney is he kind of held it out as a fact. If he just said, this is my opinion, these people are murderers, that probably doesn't lead to a defamation case because anybody's allowed to have any opinion. But when you're trying to hold it out as a fact and you know that fact is not true, that's when you run into defamation laws. So the police did as much as they could, and it's just a very fine line between free speech and witness intimidation, and it shouldn't be. For that, what I can tell you. So definitely with opening statements next week, it's going, because Monday is being Patriots Day. It's going to start with Tuesday, and I think that Hank Brennan's opening is going to be much more concise. It's going to be everything introduced is going to go towards everything he says is going to put forward to prove his case. It's not going to be a bunch of stuff where we're going to leave out the important stuff or we're going to just throw stuff against the wall. It's going to be a story. That's what an opening statement is. You're telling a story about what the facts and evidence are going to be. And that's what you want throughout the case. I'll take a few more. Do you think Judge Cannoni is trilling by fear for a trial, an appeal, or do you think she's being fair? I think she's being fair. I think she knows that the things she's keeping out, I think she knows the prosecution doesn't need, and it's kind of excessive, and they know it could be grounds for an appellate issue. She doesn't want to do this again. Nobody wants to do this again. And so I think what she's allowing in is the rulings, and what she's excluding are the correct rulings. I haven't seen anything to this date where I'm like, oh, I can't believe she ruled that way in that regard. Do you think Karen should take the stand to explain her contradictions in various interviews she done? I saw an attorney say she probably should. That's going to be a big point of contention with her legal team, because if Hank Brennan makes his case, there's nothing really left for the defendant to lose. And that's really explaining those contradictions might be her only way to kind of there's a famous saying, famous last words in politics. Let me explain. And that's kind of what the defendant would be taking the stand to say. It's like, let me explain what I meant by that. But she's too unlikable. She's not going to be able to be prepared for someone as skilled of a crosser as Hank Brennan. And by the end, he's going to literally drill her on so many things that if she takes the stand, it's because they think one of two things. Either A, they've made the case, or B, she thinks she can explain it away. Both are not good answers, not good reasons. You only take the stand when you need the jury to explain what was going through your head. Like if it was you're acting in self-defense. That's usually the one real situation. So I think I just want to hear about the new Lexus data, and we should hear that in opening statements. Yes. What you if you were to listen during opening statements, that's going to give you a roadmap of what they're going to introduce. And if they have the vehicle data, and Hank Brennan will bring it up during opening statements because he knows that the whole point of a prosecution statement, opening statement, is for the jury to think, "What are we doing here? What are we doing here? Why does the defense even need to speak? Why isn't this a plea?" So whatever they have, we'll know during opening statements. It's not going to be a situation where he's going to like leave it to the last minute. If he has it, it'll be in opening statements. So to give you your heads up about what's happening the next week. So I'll do a stream on Tuesday, 6:30. Normal time. We'll be talking about opening statements and everything like that. And then Thursday, we are kind of having a NFL draft, like kind of it'll be part Karen Reed legal cases. The other half will be the draft. So I understand. I won't take offense if that's not really your thing, but it's big things. I've had teams reaching out to my players, and I'll talk about like the process and what goes into that and what teams are thinking. So if you like sports law or sports or anything, it might be the episode for you. But for now, Matthew Timpanek signing off. Thank you very much. I'll see you guys next week, and happy Easter.